welcoming you, Green Central Station, live.normal.org, July 27th, 2011. Here with my co-host again, Ray Negril, and got a special sponsor, Cheese Castle Burger Time Speedy Taco, 1101 Army Post Road. They're open late, so give them a call, 287-4224. Now, we're going to talk about a few different things today, and then we're going to recap the episode that I did with Casey Casseday, the producer of the movie The Green Rush. That'll be coming up in the second half of the show. And right now we're going to look at the Iowa ACLU response to a medical marijuana lawsuit against the state of Iowa that was submitted by Carl Olson, and I believe Jason Karimi was assisting him. Now, Jason, as it states here on his blog at WordPress, WordPress, that he wrote the ACLU last week to request they intervene. It says, I wrote the ACLU last week to request they intervene in the lawsuit that was recently filed against the state of Iowa. Today, ACLU Director Randall Wilson responded to the request. Now, I'm going to have this up on my YouTube so you can take a look at this, or you could go to the actual WordPress website and read it. Now, basically what it states from ACLU Legal Director Randall Wilson, his response to Jason's request. Now, Jason's got a picture of Chloe Butler up here on the page, and for what reason got me. But anyway, I guess he's part of the problem here too. And says, I don't think Carl's current lawsuit against the Board of Pharmacy has any legs. Carl's suit comes close to being a mere request for an advisory ruling, something the courts generally don't do. As you note, Carl may have no injury, possible relief, or standing, and he himself seems to admit that he is filing a suit without hope of success, just to foreclose an argument that he has somehow failed to exhaust his remedies administratively before going off to court again. In my view, we won any relief the Board of Pharmacy would give on Carl's issue on the original lawsuit, McMahon versus Board of Pharmacy. And then it goes on further to state, and this is exactly what I've been trying to do since I've become an activist. We need to focus the shift from the court. The focus needs to shift from the courts to public opinion, and ultimately the legislature. Make your case there, and the results will follow. So, now I'm going to bring you Carl's announcement about the disbanding of Iowans for medical marijuana. And now going forward, the Iowa Patients for Medical Marijuana is active, but 3 of the board members have resigned for reasons that you can contact Director Jimmy Morrison if you want any more information about the organization or where we're going forward with that. But my organization, the Iowa Clemency Project, our focus is on a reform of police priorities leading towards the decriminalization of small amounts, be it a medical user or a nonviolent adult. Okay, and that's part of the problem, is Carl's focus has always been on full-blown legalization of some kind, but without the focus being on reduction of penalties for users, instead of exposing us to the same laws that are consistent as of 91, basically. Hi, thanks a lot. Now, the following will be a rebroadcast of an excerpt from Carl's Cannabis Corner on July 24th, 2011. It's got him sitting out on his desk. It looks like there's an aloe vera plant there on his deck. Now I guess they're trying to ban aloe vera too, but it's almost ironic. I don't usually like to crack on people's personal appearance, and Carl's done his fair share of cracking on so-called hippies or whatever, when he used to be. But man, if you want to see a pair of man boobs, take a look at this last episode on Carl's Cannabis Corner. But let's hear what he's got to say about the disbanding of Iowa patients for medical marijuana. No, excuse me. The disbanding of Iowans for medical marijuana and the reasons for that. And I've been saying a lot of this all along.
Laying out my argument for the appeal. And a couple other things happened this week. We decided to dissolve Iowans for medical marijuana this week. And Iowans for medical marijuana has been, for the last 20 years, 3 people. Myself, George McMahon, and Barbara Douglas. And the Barbara Douglas and George McMahon both use marijuana legally. They're both approved by the state and federal government. And I don't use marijuana. I quit using marijuana in 1990. So when we formed this organization, the 3 of us were all legal under both state and federal law. They were both receiving marijuana from the federal government and still do. And I was not using marijuana. So the 3 of us were not breaking the law. And so we've continued to make that a requirement of membership. And so we're still 3 people after 20 years. We haven't accepted any new members because we haven't met anybody that met our qualification that they be legal under both state and federal law. And so we're dissolving that because George and Barbara, their health has been certainly prolonged. Their quality of life has been improved by the use of marijuana, but they're tired of representing this cause, and they've done a lot. They've testified in court cases, they've submitted affidavits, they've been very heavily documented, and there's probably nothing more that they need to do to make the case that marijuana has medical use. And as these people, there's only 4 people in the United States still left on this program, and when the people die, they don't replace them. So it's not like that any argument that we could have made based on their use of marijuana has been made, and there's nothing really more to be said. This is not a solution for the people in the 16 states that have legalized marijuana. They're not going to get on this program. The government isn't going to provide them with free marijuana for the rest of their lives. And so the situation that George and Barbara are in is not a permanent solution. It's not a solution for everybody. It's not the answer. They were just some of the first people that were approved, and the volume and number of people now that have demonstrated a need for medical marijuana has grown to the point where it's going to take something other than the federal government growing it and providing it to people at taxpayer expense. So that organization doesn't exist anymore, so we've opened up the Iowa to whatever group wants to form to take the place. There's a group called Iowa Patients for Medical Marijuana that has got to start here in Iowa, and probably looks like that will be the organization that carries on. Not absolutely sure right now. The main thing an organization has to have is some kind of defining project, and they supported a bill last year that would have allowed people to cultivate their own marijuana. Caregivers would be allowed to cultivate it for the patients, and they wanted to set up nonprofit dispensaries. And I think that with all of the stuff going on in the United States, with U.S. attorneys threatening to shut down dispensaries and threatening states that try to authorize dispensaries, that we'd be better off if we just stuck with allowing people to cultivate their own and a caregiver to cultivate it for them, and just say that we're not going to prosecute these people, we're just not going to arrest them. and leave the question of dispensaries for another day, or else put it in a separate bill so that it's not, the two aren't tied together. I think there would be, I can't think of anybody that wouldn't support not arresting these people. Even the federal government has said that they shouldn't. I mean, what I'm saying is we need a bill that complies with what the federal government is saying, is that they won't arrest patients or caregivers. And so whatever it is the federal government is saying they're not going to interfere with, I think that we ought to start with a bill like that. We don't have anything in Iowa at all right now. You can't even make a medical necessity defense. So this would be a kind of a clemency thing. And I know there's another group that started up called the Iowa Clemency Project.
Yeah, that's
so
right. We're bringing it.
I assume that that's kind of the direction they're going, although I haven't seen any proposed legislation out of either of these groups. Except for the bill that was introduced last year that has the dispensaries. And to me that's going to be a tough bill to sell, because everyone's going to be saying, well, how do we know the federal government will not come and arrest these people? And with a question like that, the federal government has guaranteed the states they won't arrest the patients and caregivers. So I think that would be a good place to start. That's just my advice. I'm not going to introduce anything. I'm going to stick to my lawsuits. The other thing is that I'm not a patient, and so I don't have standing to make a claim that I need medical marijuana for anything. So basically, the court has given me the permission to file a brief based on my knowledge of the situation, of having been involved in it. And that kind of, I guess I'm a little surprised by that, but I took the opportunity and filed. I don't know. Well, I shouldn't say I'm surprised by it. The court just knew that I had an opinion that was different than the other parties, and so the court just wanted to hear the argument and invited me to submit a brief. So that's what's going on there. The other thing is that when this, obviously the parties wanted the DEA to rule on this so they could file an appeal. And when they file the appeal, if I tried to appeal, anybody can appeal from the DEA ruling, not just the people that filed the petition, anybody, because it's a public ruling that affects the American people. Everyone has some kind of an interest in the outcome of the thing, and anybody can appeal from a final ruling of an agency. So the question, though, is whether you have standing to make the argument, and the way the courts have kind of narrowed it down is that you have to have either a medical argument that you need marijuana for medicine, or you have to be a member, you have to be represented by an organization that represents such individuals, or you have to have an attorney. But even if your organization has an attorney, the organization still has to show that at least one or more of its members has a medical argument that they need marijuana as medicine to have standing. So I don't have that, and obviously, you know, we've dissolved Islands for medical marijuana, so any possible... the thing is, I can't represent a corporation without an attorney, and I'm not an attorney. So I can't represent Islands for medical marijuana, which is kind of the reason we dissolved it, because it wasn't really being useful to present any argument in court, and that's all I'm doing lately, is presenting arguments in court. So the brief I just filed, although that case is going to be dismissed, when the court hears the appeal, I will try to join the appeal. Most likely I won't be allowed to do that. I don't think the court is going to say that I can just appeal unless I have an argument on my own behalf where I have standing as a medical user, or saying that I would be a medical user if it were recognized as medicine by the federal government. So I'm probably going to try to file a friend of the court brief, and that's why I did such a good job, or tried to do such a good job on the brief that I just filed, because when I asked permission to file as a friend of the court in the appeal, I want them to already have kind of an idea who I am and what I'm going to say. And so that's what I basically wrote this brief with the thought in mind that I would be doing this as preparatory work for filing a friend of the court brief when the appeal is filed. And the court could easily say they don't want somebody who's not an attorney to file a friend of the court brief. But I've seen the court before appoint a law firm to file an amicus brief and ask the law firm to become familiar with all the issues because they don't feel that the two sides in the appeal, the petitioners and the Drug Enforcement Administration, are explaining all the nuances and details of the situation, and so they appoint a friend of the court attorney to brief them from a perspective that's not the plaintiffs and it's not the respondents. It's a non-biased or a third party. Now the court won't do this unless they feel there's issues that the other parties aren't talking about, but in this case there definitely are. There's a legal argument that the DEA doesn't have the authority to override a medical decision by a state government, and the fact that no official state government has joined in this case kind of leaves an empty void there, an unexplained absence of why the petitioners are all private individuals and private organizations, and there isn't any actual state official arguing on behalf of any of the 16 states that have accepted the medical use of marijuana.
Alright, well there you have it. You can watch the full episode, Carl's Cannabis Corner. Just Google him.
The other thing that's going on is I've sued the state of Iowa, saying that Iowa has misclassified marijuana because marijuana has accepted medical use in the United States, and the state government can't have a law that says it's conditional, the classification, on it having no accepted medical use in the United States, and then do nothing when it becomes accepted in the United States. Over the past 15 or 16 years, 16 states have accepted the medical use of marijuana, and the state of Iowa has just done nothing. They haven't even addressed the issue, like, did something change? So I filed a lawsuit, and the state's response is due on Wednesday on that, so obviously I'll have that to talk about next week. I'll have the response from the state of Iowa in that lawsuit, and meanwhile, I've sent the state attorney a copy of the brief I just filed in the federal court in Washington, D.C. in this federal rescheduling case. So that's about all I have to talk to. It's extremely warm in Iowa today. The humidity is unbelievable.
We're here to let you know when it's late and you look too tired for the cops. Don't punch out to them. Stay home. Munch out. Call 515-287-4224. Cheese Castle Pizza, Burger Time, Speedy Taco. They bring it late. 287-4224. Located 1101 Army Post Road for carryout. South side, just west of Southwest 9th. Bring it.